Okay, thanks everyone for joining us. Today we're going to be talking about the Australian Energy Market Commission's final report looking at the regulation of embedded networks. So I'm going to be presenting this webinar with Anne Waddell, who's our regulatory specialist. We've both been spending quite a bit of time looking at this area. Just to briefly introduce Compliance Quarter. So Compliance Quarter is a compliance business, and the majority of our work is in the energy industry. So my background, I've worked for network distribution businesses. I've worked for energy storage businesses in the past and retailers. And I'll hand over to Anne to introduce yourself, Anne, if you don't mind, and we'll get the webinar started.
Hello everybody, my name's Anne Waddell. I've been a lawyer for over 30 years now, with a variety of experience, including time at the Victorian Bar and not the drinking bar, as a barrister for a number of years, and various other roles. So recently I've been working with Connor on a lot of energy regulation matters.
Yeah, so today's webinar, we're going to try to aim for 25 minutes. We've got quite a lot of material. We're actually recording this webinar, so if you need to drop out, we'll send you the link to this webinar. We may not actually get to Q&A, but if you've got questions, just send them through to us, and we'll get started. So we're going to start off with, high level. What is an embedded network? So, Anne, do you want to just talk to that slide?
Forgive us for those of you who are already familiar with it, but an embedded network is a private electricity network connected to the distribution and transmission system of the national electricity market. They're usually found in apartment blocks, retirement villages, caravan parks and shopping centres, and they are on the increase, which is partly what has led to this review of the current regulatory framework.
Yeah, so that's right. So currently there's over 1,700 exemptions that are registered through the AER. So yeah, just also to mention, and Anne will mention this later, today we're looking at the jurisdictions that have adopted the National Energy Consumer Framework. We're not looking at Victoria. We will mention that briefly. We're not looking at WA. There are different regulatory regimes that apply in those states, which further complicates matters for those businesses that are operating across jurisdictions. So basically, the AEMC, I guess the rationale for this review is, as Anne said, the large number of embedded networks that have popped up, and it's much larger than anybody within the regulatory community had anticipated. So we've got over 1,700 registered embedded networks, and that number is increasing steadily. The AEMC is also concerned that end users within embedded networks are not enjoying the same consumer benefits that an on-market retail consumer would enjoy. And this follows on from the AER, so Australian Energy Regulator, which is the regulator of the markets, their submission to the AEMC review, basically saying the current regulatory framework is not fit for purpose. What they want to see, along with this broader concern, is both consumer protection and consumer choice. And the listeners to this webinar would be familiar with the role of the Embedded Network Manager, which has recently been introduced in NECF jurisdictions, with the exception of Queensland, where the legislation was held up thanks to their election. So, Anne, do you want to just briefly talk about an overview of the recommendations of the AEMC report?
Yeah, sure. And the reason that we've called this webinar what we have is because effectively an axe will be taken to the existing regulation of embedded networks. Under the current system, most embedded networks operate under the exemption system. Once the new rules and regulations come in, majority of new embedded network operators will exist under a new regulatory system. The existing network operators that operate under an exemption will also have increased requirements, and that's already started with the dispute resolution process that's being introduced. As Connor said, we're just talking about the NECF jurisdictions. And just another point, when you are looking at this report, as I know you will want to, or
180 pages.
Yes, 180 pages. Take it on holiday with you. You need to distinguish between the retail exemptions and the exemptions that apply to networks. There is change coming for both, but different changes for each.
Yeah, and the overall trend that's shown by this report is that the regulatory scrutiny and the level of regulation that will apply to embedded networks is going to increase. And as Anne mentioned, the important distinction between what they call legacy embedded networks and as opposed to new embedded networks. And new will be essentially, well, it's not defined at the moment, but you'd imagine that will mean embedded networks that exist after these recommendations have become law. And we'll talk briefly about that whole distinction a bit later on. So we're going to have essentially a framework of regulation that applies to two types of embedded networks based on the date that they were established. And that's replacing our existing two-tiered regulatory system, which Anne's spoken about, which is between authorised retailers and exemption holders. So with the objective of simplification, we're adding another tier, perhaps another tier and a half. In a general sense, the objectives are to increase information disclosure, to increase the standard of dispute resolution, to increase the powers of monitoring and enforcement of the Australian Energy Regulator, and to adjust the NERL and NERR, which are the National Energy Retail Law and rules, to make them actually work for embedded networks. So that ties back to this concept of the types of businesses that are coming out just weren't expected at the time when our existing set of regulation was put into place. And we're seeing that both in terms of the types of buildings, the types of embedded networks, and the types of technologies within embedded networks as well.
And when the regulator uses the expression make the law and the rules work for embedded networks, it doesn't mean that those rules and laws are working for the benefit of embedded networks. Rather, it means that they are increasing regulation for those networks.
That's right. Yep. So at the same time, if you didn't have enough reading material, in mid-November, the AER published a new version of the electricity network service provider exemption guidelines. So as Anne mentioned, the distinction between the retail side, which is the selling of energy, and selling of energy doesn't need to be a cost, so it can be for no cost, and distinction between that and the actual ownership, operational control of the network, which is the infrastructure itself. So we've seen a new guideline. One of the interesting things about that guideline was the AER's comment about microgrids. And so this is sort of one of the first public statements by the AER about microgrids, and essentially they're saying that they're supportive of that concept and with the concept of private trading, but they are concerned about, and they note that there are significant regulatory hurdles which would need to be managed.
And Connor, can you just explain what a microgrid is?
Yeah, sure. So microgrid, you could say that it extends to cover embedded networks, but it's a broader category as well. So it also includes off-market, so off-grid, communities as an example. So there's a wide degree of variation, but essentially they're isolated from the national energy market to varying degrees. And we'll be running a separate webinar specifically looking at the legal issues of microgrids next month, because we think that's a really interesting topic. And, within microgrids, you've got the possibility of peer-to-peer trading of electricity, potentially removing all of the traditional players in the energy market. And that's where, we see a lot of innovation within embedded networks, but wait until we see, the development of microgrids. I think we're going to see a lot more there. And, you've got the examples of companies like Power Ledger that do a blockchain technology to trade energy. And a lot of that will be dependent upon the development of microgrids. So next we're going to look at the key questions. And, as we mentioned before, there'll probably be some specific questions you have about your business, so feel free to send them through to us.
Yeah.
But did you want to
we'll be as you can see on the screen there, we decided that there were probably 5 key questions people needed to ask themselves. And so what we're going to do is now look at each question individually. So the first question is, what is the headline for existing embedded network operators?
Yeah, so the headline is that new embedded network operators will need to operate under an authorisation rather than rely on an exemption. There will still be exemptions, but they will be granted in a very limited set of circumstances. And also, so that's on the retail side. On the network side, embedded network operators will need to register with AEMO, the Australian Energy Market Operator. And the general concept is the concern that customers aren't enjoying the consumer protections that they would if they were on market. And on the network side, concern that the standard of embedded networks is not where it should be. You look at electrical safety, you look at the reliability standards that apply to
the type of meters.
The network, type of meters, absolutely. So yeah, just to briefly mention, there'll be some clarification once these rules are brought into play, that metering coordinator, meter data provider, they will all have a role within the embedded network, whereas at the moment, those functions are carried out by the embedded network operator themselves. So, did you want to talk about, I guess we've spoken about why the changes are made.
Yes, so really it's about this concept of that the current framework isn't working. Part of the reason it isn't working is, as Connor has said, that they didn't anticipate the types and number of embedded networks when they were originally creating the legislation. The other part of it is that the AER feels it doesn't have enough clarity around the numbers of embedded networks and how they are actually operating or complying with the provisions. So, and the third, of course, is the increased media and government attention on energy bills, prices and consumer protections. And the AER doesn't feel that it has sufficient powers in relation to enforcing or even imposing requirements on embedded network operators in relation to consumer protections.
So the next one, so the question that a lot of those, of the current companies that, and there would be many, many companies that are operating embedded networks, will they require a retail authorisation?
The answer is probably yes, if you set up your embedded network after the commencement date of the new rules. We don't know when that will be, but the other point to mention here is that an exemption is not transferable. Therefore, if you sell your property, then whoever takes over the embedded network will need to get an authorisation.
Yeah, and just as a side point, we were talking, so on the 31st of January, we've got another webinar about power purchase agreements. So those offering power purchase agreements at the moment would be familiar with the R8 exemption category, which is a registrable exemption category. So even those that are offering power purchase agreements, according, based on our reading of the AEMC report, will require a retail authorisation, so they won't be exempt. However, and we'll talk about this a bit later on, they talk about power purchase providers as maybe being a category that would require some customisation in terms of the obligations that will apply. So we would expect that they will have a little bit more room to move within that new framework.
Yeah. So, as we've said, once the recommendations are implemented, there'll be a very narrow range of activities that will be able to apply for an exemption. So, existing operators, such as managers of residential parks, won't be included as an exemption. Now, a concern for the various caravan operators and associations in Australia is that majority of caravan parks operate what's called a mixed use park, which covers both short-term holiday renters and long-term residents. Under the existing system, they're able to have the network exemption. Under the new system, they won't. The only exemption that they've been talking about at this point is the short-term holiday type park. But really, there aren't that many caravan parks that can survive simply offering that sort of accommodation.
Mm. And the big problem with all of this, as is evident in the submissions made by the various industry bodies, is the impact of this additional regulation means that it's going to cost a lot of money. It's going to cost a lot of money in terms of the systems that those operators will require, because currently they might issue paper bills or bills based on a pretty simple system. They're going to need to issue bills at a standard that would be expected of a retailer, and that costs money. The additional compliance obligations in terms of complying with the NERR and NERL will be significant, and the practical effect of this will be that there'll be a consolidation in this space. A lot of embedded network operators who aren't authorised retailers will simply drop out of the market and maybe sell their businesses. And from a consumer point of view, there'll be less choice as well.
And which could, at the end of the day, lead to monopolies. Because of the increased costs associated with this, although the reports talk about the cost not being prohibitive and that it will be able to be accommodated, I don't think that the reality of the costs, that point hasn't really been taken on board. I attended a forum last year in Sydney where this issue was discussed, and points were raised by operators of large retail shopping centres about the benefits that customers of an embedded network get apart from cost savings. The regulator then asked, well, how do you quantify those costs, those benefits, and how do you explain them? Of course, some of those benefits can't simply be quantified. The regulator was asked to, if they had estimated what the cost would be to be registered under this new system, they did not have a price or a cost estimate that they could provide to people. So it's difficult to see that they are really taking on board the costs when they can't actually tell people what cost basis they're using to say that the costs aren't prohibitive. If you look at this slide, the Commission is looking to continue exemptions where the costs of a retail authorisation and facilitating competition would outweigh the benefits to customers, and the need for regulatory oversight is low. Now, there's a number of community housing projects that offer housing to low-income earners. As part of that, a number of them are looking at embedded networks, introducing solar systems and various other things to reduce the cost of electricity. Those type of projects will not, under the current recommendations, will not be excluded. As I said to Connor earlier, if you look at this definition of costs of retail authorisation and facilitating competition and need for low regulatory oversight, I would have thought community housing fitted that bill. So I don't know. As we said, the only one that they've really mentioned specifically are short-term holiday parks. But, you know, if they can't tell us what they are estimating the costs of a retail authorisation are, then how can they make this assessment?
Yeah, and I think, you know, based on our experience, so at Compliance Quarter, we, over the last 6 months, I'd say that we've managed probably 80% of the retail authorisation applications that are, have gone through the AER. We're managing 80% of the current retail authorisation applications. And I can tell you, you know, the rule of thumb from the Australian Energy Regulator is that they would expect you to be able to fund the business over 12 months on the assumption of no revenue at all. And so in the context of an on-market retailer, obviously a significant component of that is the wholesale costs of purchasing energy, which wouldn't necessarily be a cost of an embedded network retailer. However, you know, if you look at the costs of running a billing system, of employing staff, metering and compliance, you know, that could very, very quickly run into the millions of dollars. And it's not the sort of business that you can set up based on, you know, financing your family home. It requires significant financial resources.
Which again talks to that point of whether we then get to the stage where there are only a few companies that will be able to operate embedded networks, and owners of property that has an embedded network will have to then enter into contracts with these organisations that are allowed to.
Yeah, and they talk about that, so which is a little bit inconsistent with the current guidelines. So, you know, in the current guideline, if you're in any way involved in the sale of energy, then you need to be exempt or authorised. The AEMC report talks about the possibility of partnering up between a authorised retailer and an embedded network operator as a possible way for people who are concerned about costs to overcome this. But, you know, the underlying, you know, so the point from the AEMC, which I think is fair, is that it shouldn't matter where, from the consumer's perspective, it shouldn't matter if they live in a, you know, multi-million-dollar apartment or a community housing project. They should enjoy the same consumer protections. And of course, that's reasonable. They should enjoy, you know, the benefit of the hardship provisions. But, you know, the practical reality is there's a wide degree of variation in the motivations of embedded network operators, and some that are in it for profit. And they're the ones that, you know, might operate embedded networks where the customers within those embedded networks are paying more than they would if they were on market. But then, you know, you have the other end, and you've got the community housing project providers, and Stucco is an example in Sydney. And they're doing that purely for the benefit of the occupants. So the hard thing from the AEMC's perspective is, where do they draw the line? And they can't make an assessment of the motivations of the operator. They just need to look at it from the consumer's perspective.
Yeah, that's a good point. So how do I obtain a retail authorisation? It's proposed under the recommendations that a new category of retailer will be established, which will be basically the embedded network operator. However, it's unlikely that the AR would exempt new authorised retailers from any of the consumer protection provisions or many of the other provisions.
So they spent a bit of time on this concept of, a more flexible retail authorisation, but then they looked at, the existing requirements, and then they sort of said, oh yeah, well, we'd need this. And then at the end of the day, the list of what they would need is much longer than the list of what they would remove as an obligation on that new category of retail authorisation holder.
So there probably won't be much different.
No. How, under the current obligation or current rules, how would somebody go about becoming an authorised retailer?
Okay, so an application is made to the AER, and in considering the application, the AER must be satisfied that the applicant has the necessary organisational and technical capacity to operate as a retailer. Our experience in relation to this element is that if the director of the new company, or the applicant, I should say, doesn't have sufficient experience in the energy market, the AER will want them to employ someone who actually does. So it's important that within the organisation, either as a consultant or as an employee, that the organisation has within its structure someone with energy retail experience. That's something that they really look for.
Yeah, and that's one of their current focuses. They're also particularly focused on making sure that the business can fund its operations. And the reason for their concern is they don't want to see another retailer go into administration. If you look at the wholesale prices, over the last 18 months, there's been a lot of variation, periods of very high wholesale prices. And for an on-market retailer, what that means is they need to, put up a lot of money to in the guarantees, and they also need to pay for their energy. So as embedded network operators become retail authorization holders, that component won't be as important. However, they would want to see that that business has appropriate financial resources to run the business, and also understands the risk within the gate meter supply contract in particular.
And to run the business for a couple of years without getting a return.
Yeah.
That's, you can make a projection of what you anticipate your return will be. However, when looking at the applications, the AER tends to look at it from the point of view that you won't be making a return in your first year.
And so the application document itself, once you've got through all of that and you've got the money and the people involved, as I said, we've written a bunch of them, and it runs between 306 or 700 pages as well. So
yeah, because you need to, the application itself is usually about, 15 pages, 20 pages, but you then need to annex a number of documents to the application in support of it. And they include things like your hardship policy, complaints management, risk policies, business plan, various other things like that. So it is a complex process.
So we'll just quickly skip through the next couple of slides. I'd say, as we've mentioned, there will be a difference in terms of the requirements that apply to embedded network operators. And as we mentioned, there will be circumstances where the AR will be given discretion to vary the standard conditions that apply to a retail authorisation. However, they're going to still be focused on ensuring that there are systems in place, that bills are sent out in the correct format, that customers enjoy hardship provision and so forth. I'll just quickly talk on this one. Existing embedded networks, will they be grandfathered? So we've spoken about the separation between new and legacy embedded networks. The AEMC engaged Minter Ellison to look at the options for dealing with legacy embedded networks. So legacy embedded networks are those that exist at the moment. Even those will be subject to a range of new conditions by the amended exemption guidelines. So Minter Ellison identified that there's not really an intention that the obligations will be retrospective. However, I think they came up with 5 possibilities, in terms of moving 6 possibilities, thanks, and 6 possibilities in terms of dealing with existing embedded networks. So they can preserve existing exemptions indefinitely, wait until there's been substantial changes to the network, look at pushing everybody over to the new framework all at once, put in a cutoff date, and also just generally have a grandfather provision, but have some sort of registration requirement. And another concern is, so as I mentioned, there's 1,700 exemptions, embedded network exemptions, probably more than that now. In the whole of Australia, there would be far more embedded networks. So you talk about those that are registered and operating under an exemption, there will be plenty of embedded networks that have no idea that they even need an exemption, or that there is such a thing as energy law. So the preferred option from Minter Ellison is 4 and
number 6.
3.
So
that's right.
their preferred option is number 6.
Yeah.
Which is requiring current holders to notify by a particular date. Their other one is also 3 or 4, which involves
the sale of the embedded network, which would be interesting from a legal perspective, in terms of.
Well, no, they say preserve it until it's sold.
Until it's sold.
So,
right. Yeah.
As we said before, you can't transfer an exemption. So, once a property's sold, that exemption will end. But that's quite I guess, in a way, limited. So, 1, 2, and 5. You can pretty much disregard. So the ones that they are focusing on, and which presumably the regulator will focus on, are 6, 3 and 4 on this list.
But I guess, this whole question of grandfathering, it's an important question for those businesses that are pretty static and they're not taking on new embedded networks. For those businesses that run an embedded network operation, they're really going to be looking at both the grandfathering provision, but also the obligations that apply to new embedded networks. So the conclusion is, this is the current state. This is what we know at the moment. There's going to be quite a bit of back and forth. So the changes that they're recommending will require a raft of legislative changes. There's going to be more consultation between then and now about particular components. So there might be an opportunity for further submissions by parties that are affected. Those changes will then go to COAG, and then they'll need to be legislative. So that's definitely not going to happen until, the very earliest would be late this year, I would say. And so that concludes the webinar for today. We've got a bit of information about compliance quarter. What I might do just quickly for those that are still with us is take a look at the questions that we've received. Okay, so yeah, sorry, Christopher was having issues with the audio. So we'll send a recording and hopefully that'll help with that. And from James, is size of an embedded network an issue, or are all embedded networks affected? So size isn't something that they would consider.
I haven't talked about.
No.
It may be that they put them into classes, and if there are numbers under a certain amount, they might impose less requirements, but they haven't, when they're looking at what will be covered by the current exemption framework, they haven't looked at it from the point of view of, let's say, 30 customers or under or anything like that.
No, and that goes back to that concept of, you look at it from a consumer's perspective, they shouldn't be disadvantaged by the fact that they're living in a particular embedded network as opposed to a larger embedded network. The only way that it might be relevant is in terms of the cost of compliance. However,
Sure.
I would say that is much less of a concern than ensuring the regulatory obligations are across the board and that, you know, consumer protections are in place. So that's the end of our webinar. You know, thanks very much for joining us today. We had a large number of participants in this webinar, and as I mentioned, our next webinar will be on the 31st of January about power purchase agreements. If you've got any topics that you'd like us to cover in the future, so the intention is we're going to run at least 2 webinars per month, because there's plenty of regulatory updates that you'll need to
That's probably not even enough, but that's enough for us.
That's enough for us. And we'd be happy to hear from you, and have a good day. Thanks for joining us.
Thank you, everyone.